Dear students, good morning. I hope you all are in fine health. Today we will revise chapter 4 of Civics, Supreme Court. This chapter is one of the most important chapters of our syllabus, okay? And we are to go through its syllabus thoroughly. So, in this chapter, we are to study about only the Supreme Court. In fifth chapter, we will revise about the High Court. In this chapter, we will revise about the composition, qualification of judges, appointment, independence of judiciary from the control of executive and legislature, jurisdiction and functions, which include original jurisdiction, appellate jurisdiction, advisory jurisdiction, revisory jurisdiction, judicial review, and court of record, enforcement of fundamental rights and writs. Okay, so we will revise by questions. So first question is, the Supreme Court of India is the supreme judicial authority and the highest court of the Republic of India. With reference to this, we are to answer the following questions. First question is, who appoints the judges of the Supreme Court? Mention any three qualifications required for a person to be appointed as the judge of the Supreme Court. So, the answer to this question is given on page number 238. So, first question was appointment. So, who appoints the judges of Supreme Court? It is the President. Every judge of the Supreme Court is appointed by the President of India, but in consultation with the judges of Supreme Court and High Courts beside the Council of Ministers. Okay, so we are to learn the qualifications of judges also. First qualification is she must be a citizen of India. If the person is not the citizen of India, he cannot become the judge of the Supreme Court. So first qualification is citizen of India. Next, there are three qualifications. A person must be holding any one qualification from the next 3 points. First point is he has been at least 5 years a judge of a high court. We are to learn and mug up this point that he should be a judge of a high court for more than 5 years. Means at least 5 years he should have been a judge of one or the more high court, and restly it can increase to an extent. He may be a judge of high court for more than 10 years, for 20 years, or even for a 30 year, but minimum 5 years. Or he has been at least a 10 years an advocate of a high court or of two or more such courts in succession. Okay, so she must be a advocate of one or the more high courts, but the time should be minimum 10 years and 10 years should be in succession, means it should be continuous 10 years. Third qualification is, or in the opinion of the president, he is a distinguished jurist. Okay, so these are the three qualifications, and an MCQ can also be asked from these qualifications. Second question is, under Article 129, the Supreme Court of India is called a court of record. Justify the statement with 3 points. So here we are to tell about the court of record. The answer to this question is on page 242. Court of record. What is the meaning of court of record? A court of record is a court whose judgments are recorded for evidence and testimony. The judgments are in the nature of precedents. That is, the high courts and other courts are bound to give a similar decision in a similar case. They are not to be questioned when they are produced before any subordinate court. So, what are the key points in this point? First is evidence, second testimony, third precedent. Okay, so these are the key words of this point. Court of record means a court whose judgments are recorded as evidences and testimony. Okay, so what are the implications of this court of record? Firstly, its judgments and orders are preserved as record. They can be produced in any court as precedent. For example, the Supreme Court has given any kind of verdict, and if you are to file any case against any authority or any person, you can produce that judgment as precedent or evidence, and in that case the high court will be bound to give a similar decision. Okay, second point is, if a person commits a contempt of court, the court has the authority to punish him. Any person who shows any kind of disrespect to the Supreme Court, how a person can show disrespect to the Supreme Court? By not obeying the orders and commands of the Supreme Court. So if the person is not obeying to the commands of the Supreme Court has the authority to punish him. Okay, so this is the court of record. Next is, we are to explain the following terms. First is revisory jurisdiction. Second is advisory jurisdiction. Revisory, page 241. So what is the trick to learn this revisory jurisdiction? What is the meaning of revise? So we had completed this chapter before winter vacations, and now we are revising this chapter. Okay, we are learning the chapter so that the things which might have left in our teaching, so we can cover up those things, and if some things which have been missed in your understanding, you may cover up those losses. So revisory jurisdiction means any judgment or order made by a view to remove any mistake or error that might have crept in judgment or order. Means to review its own judgments. Why? To remove any kind of mistake or error that might have left in the judgment. So second question was advisory. The answer to the same, the question is also on the same page, that is 241. What is advisory? Advisory, to give advice. The Supreme Court has the advisory jurisdiction on any question of law or the fact of public importance as may be referred to it for consideration by the President of India. So it means that Supreme Court has the power to give its advice to the President of India. But you must be sure that the advice given by the Supreme Court is not bound on the president. Okay, so the advice is not bound on the president. Next question is, the Supreme Court of India is the final court of appeal for all civil and criminal cases. With reference to Supreme Court, answer the following question. Question A. Mention any three cases which come under the original jurisdiction of the Supreme Court. Original jurisdiction. The answer to this question is given on page 240 and 239 and 240. Original jurisdiction. What is the meaning of original jurisdiction? Original jurisdiction means the power to hear and determine a dispute in the first instance. That is, those cases which cannot be moved in any court other than the Supreme Court. It means the cases which will go to the Supreme Court directly. No other court can hear those cases. So, first case is center state or interstate dispute. Okay, so there are three sub points which are given this in this point. First is between government of India and one or the more states. So if there is if there is any dispute between the government of India on the one side and one or the more states on the other side. Second is between government of India and any state or states on the one side and one or the more states on the other. So one or the more the central government and one or the more state governments are on the one side, but and on the other hand it is one or the more state governments. Third point is between two or more states. Okay, for example, Punjab and Haryana are having any kind of dispute, so it will go to Supreme Court. Second point is protection of fundamental rights. So if your fundamental rights are violated, you can go to the Supreme Court directly, and in that case Supreme Court will issue several writs for the protection of your fundamental rights. Okay, so what kind of writs can be issued by the Supreme Court? It is given on page 242. First writ is writ of habeas corpus. It means to have the body of. Okay, so Supreme Court by the writ of habeas corpus, you can go to the Supreme Court, and if any authority which has illegally detained any person, that authority has to produce that person before the Supreme Court. Second is mandamus. Mandamus means we order. It is the command of a superior court to a lower authority to perform certain duty. Means we are ordering, Supreme Court is ordering an other court to perform his duty. Second is writ of prohibition. What is the meaning of prohibition? Prohibition means to stop. Okay, so it is the order given by the Supreme Court to any court to stop the proceedings in the case which might be in excess of the jurisdiction of the lower court. Third is certiorari. What is the meaning of certiorari? To be certified means to be informed of what is going on. What are you doing? Okay, so it is issued by the Supreme Court, but it is issued by the Supreme Court after an order has been passed or after a case has been solved by any other court. Third is quo warranto. Quo warranto means by what order? By what authority? You are holding any kind of office. Okay, so if the person who is not entitled to any office and he is holding that office, this writ can be issued against him. So third case of original jurisdiction is transfer of cases from lower courts. So Supreme Court can transfer a case from lower court to her. Fourth is interpretation of the Constitution. Interpretation of the Constitution means to take the meaning of the Constitution. Fifth point, what can we write here in original jurisdiction? It is judicial review. Okay, what is judicial review? Judicial review means the Supreme Court can declare a law ultra vires or null and void if it is against the letter and spirit of the Constitution or contravenes the provision of the Constitution. This power is referred to as the power of judicial review. For example, if any law is made by the parliament or any state legislative assembly and that is against the provisions of the Constitution, the Supreme Court can declare that law null and void, means unconstitutional, and that law will be removed from the country. That law will end at the time when the Supreme Court declares the law ultra vires. Third most important question: for the efficient working of judiciary, the independence of judiciary is must. Mention any 4 points to ensure the independence of judiciary. So we are to write any 4 points which shows the independence of judiciary, or by following we can ensure the independence of judiciary. So the answer to this question is given on page 238 and 239. There are total 10 points. Okay, I will be revising you all these 10 points and you are to learn any 5 points. First is appointment of the judges. Okay, so we will write about the appointment of the judges of the Supreme Court. How the judges of Supreme Court are appointed? They are appointed by the president on the advice of cabinet and other judges of Supreme Court and Chief Justice of India. Second is removal of judges. So although the topic removal of judges or the impeachment of judges is not there in our syllabus, but the procedure is similar to the procedure to remove the president of India, that is by impeachment. So a judge of the Supreme Court can be removed by impeachment. Third is security of tenure. A judge of the Supreme Court holds office till he attains the age of 65 years. Okay, she cannot be removed before 65 years. Third is security of salaries and services. So the salaries and what kind of the services which are given to the president, like the judges of the Supreme Court, like home, security, their cars, okay, food. This is the service that is given to them. What is the salary that is given to a judge of the Supreme Court? The Chief Justice of India draws a salary of rupees 2,80,000 per month, and other judges draw the salary of rupees 2,50,000. So the salary of the judges is same. Okay, it cannot be reduced except in financial emergency. Next is freedom to announce decisions and decrees. So the judges of the Supreme Court, they can announce any kind of decision, and when they are announcing the decision, they are not having this feeling that after delivering their order, they will be having any kind of threat to their life or their property. So next is punishment for contempt of court. If any person or authority makes any kind of attempt to lower the authority of the Supreme Court, the Supreme Court can punish that person. Okay. Seventh point is full control over its procedure of work and establishment. The Supreme Court is free and is independent to have full control over the whole judicial system in India. Next is no decision in the legislature on the conduct of judges. So in the legislature, that is in parliament, you cannot discuss the behavior of a judge except when impeachment is going on. Ninth point is prohibition of practice after the retirement. If a judge is retired from his post, he cannot practice after retirement. What is the meaning of practice? Means he cannot become a lawyer after his retirement. Why so? Because if he is given this independence, he can influence his colleague or any kind of prospective employer. 10th point is live streaming of the court proceedings. So the Supreme Court proceedings are live telecasted on television. So now we will discuss about MCQs. This is a table which shows the details of the Indian citizens. We are to select the ones who are eligible for appointment as a Supreme Court judge. Okay, so option P is age Candidate P, age 65, he is a distinguished jurist. Q, age 61, has been an advocate of High Court for 10 years. R, 67, has been an High Court advocate for 5 years. S, 56, has held a judicial office for at least 10 years. So these are the options. Option A, P and R, B, Q and S, C, R and P, D, Q and R. Okay, so you are to tell me the answer of this MCQ by personally messaging me. Second MCQ, when the Supreme Court reviews any judgment made by it to remove an error, it falls under dash jurisdiction. A, advisory, B, revisory, C, original, D, appellate. Okay, so these are the two MCQs which you will solve on yourself, and you will tell me the answer by personally messaging me. Dear student, it is one of the most important chapters. Please do not ignore this chapter. Okay, you will be finding a 10 marker question in your board exam from this chapter. Okay, thank you so much.